Hello everyone. Thanks for being here today in our webinar in space law. My name is Adrian Saez and I am here in representation of iSpace School. I would like to introduce Dr. Anja Nakarada Petrigli, which is our lecture today. So Dr. Anja, the floor is yours. Thank you very much.
Thank you so much, and thank you for the invitation to present to you today. And I want to just greet everyone in the audience. I will do my very best to intrigue you with a specific area of law, the international space law, which I find one of the most dynamic area of law and completely the opposite of being boring. Um, Unfortunately, today we don't have Q&A session, and we cannot go into very specific details and also into case studies, which is going to be offered at the course, which you will find information at the end. But still, I'll try to pass on to you what are the main principles, how the international space law came into being, and what are its main challenges. So let's start. As I said, well, at the beginning, I'm just going to introduce myself a bit, and then I will talk to you about the history of space law, the main outer space treaties, and in the concluding remarks, I will address what are the current biggest problems and where the international space law community is standing and what it faces that it needs to resolve in the future. So just briefly about myself, I recently, well, this week defended my thesis in space law. So this is also a premiere for me to give a lecture as a full doctorate in space law. I was doing my PhD research at the Institute for Air Law, Space Law, and Cyber Law in Cologne, which is one of the most renowned institutes that deals with space law and actually has a very long tradition of focusing on this area of law. Currently, I'm working at Axel Space. That's a space startup from Japan as a business creator for Europe. So you can see that as a lawyer, you have many opportunities and you're not bound by exclusively doing legal stuff. It always comes in handy that you graduated law and are professional in it, but you can also shift to some other areas and stay in the domain that you find interesting. In addition, I also started a foundation in Serbia, where I come from, with some colleagues from Belgrade. It's called Serbian Case for Space, and it's a non-profit where we try to motivate as well Serbia to engage more in the space domain. And this is how we also established our connection to iSpace School, because we're trying to educate young people why space technology is so useful nowadays, and how can also a country that is not a space power can still be a valuable participant and can extract a lot of benefits for itself. I'm a member of the International Institute for Space Law, the European Center for Space Law, and I'm also national point of contact for SJC, which is the biggest network for every student and young professional up until age of 35 that would like to connect with other peers and do some interesting voluntary projects and just participate in the discussions. So let's begin. In order to explain the history of space law, we have to understand exactly the time of human history when it came to being. So after the Second World War, even though the humanity was hoping that there will be no more conflicts, there was a big conflict that we entered to again that was not like previous wars, of course, but US and USSR since the 47 started a long Cold War that ended only in the 90s. In the Cold War, among other things that they were racing and competing and trying to establish their dominance was also space. So they began the space race in 1955, seeing who is going to be the first one to launch a satellite into outer space, to send a human mission, and to get to Moon. The USSR, surprisingly at that time, was the first one that successfully launched Sputnik 1 in 1957. What this meant at that time is that both sides realized that this is way too dangerous. We are able to send interballistic missiles into outer space. This can mean that we can easily destroy life on Earth. So even though they were racing each other and had so many conflicts all around the globe, when they realized that the technology is there, that we can reach outer space, they were absolutely determined to sit at the same table and make some ground rules. In order to make it neutral as possible, they tasked United Nations and asked United Nations to be the forum which is going to create the first norms. So in 1958, a year after the first launch of Sputnik 1, it was created an ad hoc committee called Committee on the Peaceful Uses of Outer Space, UN-COPUS, and it had 18 states in the beginning. Already next year, it was determined that it's not sufficient to have this committee only for 1 year, but to make it a permanent United Nations body. So from 1959, there is a permanent United Nations body that deals with all peaceful uses of outer space. Now, this body has grown in the meantime from the 18 states that started, and now it counts around 95, I think, this year. So all the major space powers are there represented, as well as other countries that are less of space powers, or that they're even not having a current space agency or space missions. However, they want to participate in the discussions. The UN-COPUS has two subcommittees. One is Scientific and Technical Subcommittee, which always has its meetings in February. And the other one is Legal Subcommittee, which has its meetings end of March, beginning of April. Both of these subcommittees report to the main committee, which usually takes place in June. In these subcommittees, the most relevant issues are discussed, and member states send their delegates, which are usually people who are experts in those fields. So for the Scientific Technical Subcommittee, engineers are sent, and for the Legal Subcommittee, lawyers are sent. Legal Subcommittee was the one where the space treaties were negotiated, drafted, and then adopted, sent to the main committee, which then adopted them and opened for signature for states to sign it and to ratify. So in 1967, we got to the very first international convention that was regulating space activities, the Outer Space Treaty. So you see that it took 10 years from the moment of the launch of the very first satellite to the moment where we got first norms in place. That we have that are regulating outer space activities. As I mentioned, the number one, the first one created, and the most important one is the Outer Space Treaty. This is considered as a constitution, so to say, of outer space activities, because it entails all the most important principles, which we're going to go through, and regulates everything that is happening in outer space. Some of these principles, even though they are laid down in the Outer Space Treaty, they needed further elaboration. So that is why we have 4 more subsequent treaties that followed the Outer Space Treaty. In 1968 already, we have the agreement on the rescue of astronauts, the return of astronauts, and the return of objects launched into outer space. Now, this was very important to the US and USSR at that time, because they were the only one who were able to send astronauts and to launch objects in outer space. And they wanted to make sure if something happens to the astronauts or the objects land on a different territory, that they are safely returned to the country of origin. Other states supported this treaty, and they accepted to adopt it only if United States and USSR were willing to adopt the third treaty, which is the Liability Convention. So it was, in a sense, quid pro quo between the space powers that wanted their objects and astronauts to be returned, and between the states that were not yet active in outer space, but that wanted to make sure that if any damage happens to their territory or their objects, then that the space powers should be liable for it and pay for this damage. And this is how the third convention also got adopted. The fourth convention, the Convention on Registration of Objects Launched into Outer Space, the Registration Convention, deals what information is necessary to be registered in the United Nations, where the registry is held, to provide information on the objects that are in space, and so that we can follow and have a more clear view and not have a complete chaos out there. The fifth and the last treaty that was adopted is the Moon Agreement. Now, this is unfortunately it has a bit of a bad reputation in the sense that not many states have ratified it. And outer space activities. I want to go with you through the main principles that are regulated in the Outer Space Treaty, because this is the core of understanding the international space law, as well as what is allowed to do in outer space. So even though if you are an engineer or a data scientist or simply a space enthusiast, not only technical obstacles need to be overcome in order to have a space mission, but also the legal norms need to be followed, or you're not going to be able to launch your satellite or your, very innovative spacecraft into outer space. So let's start with Article 1. It says, the exploration and use of outer space, including the moon and other celestial bodies, shall be carried out for the benefit and in the interest of all countries, irrespective of their degree of economic or scientific development, and shall be the province of all mankind. Now, this is extremely important principle. It's the first one. And the very first sentence says that outer space affects us all. So when I'm asked in Serbia, for example, why should we care about outer space? We don't have a space program. We don't have space capabilities. Yes, that's true. But space still belongs also to Serbia as to anyone else. So we should care, even though we're not there yet. Shall be the province of all mankind means that outer space is a global common. It doesn't belong to anyone, or it belongs to everyone, how you like to observe it. And we only have 3 global commons that are regulated under international law: high seas, Antarctica, and outer space. Now, the second sentence gives the main freedoms for activities in outer space. So, outer space, including the moon and other celestial bodies, shall be free for exploration and use by all states without discrimination of any kind, on a basis of equality and in accordance with international law. And there shall be free access to all areas of celestial bodies. So this second sentence gives us freedom to explore and to use outer space. This sounds extremely broad, of course, and that we can use it and explore it as we want. And this is to a certain point true, but then we have to look at other provisions that are also adopted and see what kind of limitations of this freedom we have. So in Article 2, we have the first limitation to this freedom. It says, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty by means of use or occupation or by any other means. This means, and you can always then answer to the question, can I buy property on Moon or Mars? No, you can't, because nothing in outer space is subject to personal ownership. You cannot own the land on the Moon, on Mars, on asteroids. It simply cannot be owned because no one has an ownership to pass it to you. It's a global common, as I mentioned just in the previous provision. And there was a case of a guy in the US who thought that he was clever and that because outer space doesn't belong to anyone, he's going to be the first one to claim it. And he started selling parcels on Moon, I think. And people actually bought it. And then it went to court. And of course it was nullified and he had to pay back because he cannot sell something that he doesn't own. Just also to clarify, when NASA went to the Moon and they placed their flag on the Moon, that wasn't claiming of territory, that was just a symbolic gesture that they made it to the Moon. Article 3 is another limitation of freedom in outer space, because it says that all activities in the exploration and use of outer space, including the Moon and other celestial bodies, have to be in accordance with international law, including the Charter of the United Nations. This means that not only provisions which are here in the Outer Space Treaty regulated, but also in the Charter of the United Nations, as well as in other sources of international law, apply to outer space. So it's not like it's a Wild West and you can do whatever you want and say, well, Article 1 says we are free to explore and use. No, it still has to be in accordance with already established norms of international law. Article 4 is another limitation to the freedom, and it explicitly says that we are not allowed to put in orbit around the Earth any object that is carrying nuclear weapon or any other kind of weapons of mass destruction. Now, this is, of course, a limitation. You're not allowed to put these two types of weapons in orbit. But we see here that there is only mentioning of these two types of weapons. So it doesn't talk about other types of weapons, which leaves the question, are they allowed? The second paragraph of this provision says that the Moon and other celestial bodies shall be used by all state parties to the treaty exclusively for peaceful purposes. Now, this doesn't talk about orbits, which is still then left to question what can be put in orbits, but it says that on the Moon and celestial bodies, there should be exclusively peaceful purposes. Since space technology is of dual use, it's always the question of what is exactly peaceful purposes. Does that mean that we can't even put the technology there that could be used in military purposes? The international law community tends to say that this is allowed under this provision, and that actually the things that are forbidden is to use that technology aggressively. So to cause any type of, like to use it for military action that would cause aggression. But military missions are allowed, especially if they are scientific military missions, testings of like parts of technology. You can send a military satellite up there. That is how GPS came to being, for instance. So there is a huge gray area on what can be interpreted to be allowed. Article 5 is the first article that talks about astronauts, and it refers to astronauts as envoys of mankind. Now, this is in my humble opinion, a very nice definition of astronauts, and it gives a lot of respect to astronauts, and they're treated almost as diplomats, and they need to be treated with this respect, especially if they're in some sort of distress situation, accident, all help needs to be offered to them. But questions that came afterwards, after 1967, when this treaty was adopted, is the exact definition of astronauts. Who is an astronaut? I mean, obviously, we know if a NASA astronaut, European Space Agency's astronaut, like now when they're having a call for new group of astronauts. But what about the paying tourist? If I pay my ticket to outer space, go to a 3-week training, they approve me, I'm in perfect health conditions to go up, am I an astronaut? And if something happens to the spacecraft and we fall somewhere, are other states obligated to then render all help possible because I'm an astronaut, or they can ignore that because I'm a tourist? These questions still don't have a definitive answer. Article 6. Now, this is a very, very important article, and it was actually heavily discussed during its adoption because at that time, USSR was against having any mention of private sector in the space treaty because their also political system only foresaw that there will be governmental activities in outer space. Whereas US was insisting of including also private sector, as they were anticipating that private sector at one point will be the one who will be more engaged in outer space activities. At the end, the compromise was found with Article 6, where it says, state parties to the treaty shall bear international responsibility for national activities in outer space, including the moon and other celestial bodies, whether such activity is carried on by governmental agency or by non-governmental entity, and for assuring that national activities are carried out in conformity with the provisions set forth in the present treaties. The activities of non-governmental entities in outer space, including the moon and other celestial bodies, shall require authorization and continuing supervision by the appropriate state party to the treaty. Okay, now let's a bit defragment this provision. So first of all, only states can be party to this treaty. This is an international law treaty, so only states can be members of the treaty. They need to sign it, they need to ratify it, and then they're obligated to follow it. So if a state signs a treaty, and most of the spacefaring nations have signed this treaty, we have 110 signatures now for the Outer Space Treaty. That means that they are internationally, so in front of all the other states, they're responsible for all their national activities. And these national activities can be either their agencies or their private sector. Just to give you one brief example, because we don't have too much time to go into details, but what everyone is talking now about Elon Musk and SpaceX and what they're doing. So even though Elon Musk has these amazing ambitions to launch so many satellites that we have global connectivity and to get the first human mission to Mars, he's not acting, even though he's a private company, he's not acting outside of the international space law regime. So even though he is not a party to the treaty obligations indirectly also affect him as a private person, as his private company, because in order for him to get approval by the United States, to get all the licenses that he needs and other authorization bureaucracy that he has to go through, he has to comply with everything that's written in these treaties. Because if he doesn't comply, that means that United States is not complying. And that means that any state could take a legal action against United States and accuse them of breaching an international treaty. And of course, United States doesn't want to be in breach of a treaty. That's why they have to really look in detail what their private sector is doing, and they're only going to issue permission if they're certain that there is no breach of any of the treaties. I hope this is clear, and I'm happy to discuss this further at our course, because we're going to go into many examples of private sector and what they're doing and what happens even in the case when they don't obtain a license and still do a space activity. So Article 6 was talking about responsibility. Article 7 talks about liability. And now this always comes tricky to people to understand, especially coming from being non-native in English, because in other languages, there are no distinction between, well, I don't know about every language, of course, but for example, in German, and I do think in French as well, there is no distinction between responsibility and liability. However, in English, there is. And the Article 6 is simply talking about breaching a legal provision. So it doesn't have to be any type of damage caused. You just had to do something which is not in accordance with law in order to be responsible. Article 7, on the other hand, is talking about physical damages and who is liable for physical damage. Now, it says, it defines the launching state, and it has 4 options who is a launching state. Each state party to the treaty that launches, 1, procures, 2, the launching of an object into outer space, including the moon and other celestial bodies, and each state party from whose territory, 3, or facility, and 4, an object is launched. So you have four options who is a launching state. And this can get very complicated because you could have, for example, let's say Ethiopia wanting to launch its first satellite, then procures the launch in India, and India takes the satellite to coastal waters of Sri Lanka, where from the water platform, a rocket is launched carrying a satellite. So technically, you have the state that procured, the state that launched, and the state from whose territory it was launched. And these complex situations are very often the case in practice. That's why states usually at the beginning have to agree which of them is going to be the launching state in order for other states to know who to address in case there is a damage. So far, we haven't had any case of this happening, actually. The only 2 cases where a damage did occur was when a satellite fell down on a Russian satellite that came down on Canadian border, a Canadian territory, but they discussed this through diplomatic channels, and there was never a claim that went officially to a court. The second damage that happened was a collision of 2 satellites, of a Russian one and from United States. And there again, it was resolved through diplomatic channels. There was never a claim. But seeing that we have more and more activities, more and more states, more and more satellites, it's not unthinkable that there will be a damage caused, which will then go to actually court and into a legal procedure to pay accordingly for the damage. Now here we see in the Article 7, it doesn't say if there are any criteria how the other state is liable. Does it have to be some fault involved, negligence, whatever? This is the reason why states were insisting on adopting Convention number 3, the Liability Convention. So there, in the Liability Convention, we have a lot more information on what it exactly means to be liable and what are the conditions. Article 8. So even though outer space is a global common and it belongs to everyone and you cannot claim ownership, that doesn't mean that when you launch an object into outer space that you lose ownership. And exactly that is what is regulated under Article 8. So state party to the treaty on whose registry and we'll talk about this as well, an object launched into outer space is carried shall retain jurisdiction and control over such object and over any personnel thereof while in outer space or on a celestial body. Ownership of objects launched into outer space, including objects landed or constructed on a celestial body, and of their component parts, is not affected by their presence in outer space or on a celestial body or by their return to the Earth. Just to clarify a few terms here, a registry is something that is further explained in the convention number 4, so the registration convention. What is a registry and what information needs to be sent, written down in this registry. So the state party which registers an object is the one which retains jurisdiction and control. Now, what does it mean, jurisdiction and control? Jurisdiction means that it retains its legal rights, and control means its practical rights, in the sense it has its physical ability to control an object. Same applies to the personnel. So if you go on a group mission with many countries sending their astronauts, as is the case for International Space Station, still the country that's responsible for their astronaut is the one that sent it. So just to sum up this article, if you do decide to launch something into outer space, you're retaining the ownership, you're not losing it. Article 9, which is the last one that we are going to look into from the Outer Space Treaty, is the one that promotes cooperation in outer space. So it says, in the exploration and use of outer space, including the moon and other celestial bodies, state parties to the treaty shall be guided by the principle of cooperation and mutual assistance, and shall conduct all their activities in outer space, including the moon and other celestial bodies, with due regard to the corresponding interests of all other state parties to the treaty. There is a debate about this provision, saying if this is like a very hard obligation or is it more a recommended principle, because how can you actually force someone to cooperate? However, really, outer space is one of the domains which is a prime example of cooperation, especially if we look at the International Space Station. And also if we go back to the origin story of how international space law was created, because it was realized that it is simply too dangerous to act alone, to not take into account others, and that it's better that we set rules and that we try to cooperate in this completely new and very exciting area, but that brings with it a lot of risks. And indeed, states cooperate a lot in outer space, and they're guided by this principle, and they do try their best, even though, of course, there are always some examples that are not perfect, but they still try to exhibit this due regard to other countries. It's not that if one state gets certain frequency or certain orbit, that another state is going to go and try to occupy the same or like the same part of the orbit. Like there is certainly a high degree of exhibited due regard so far in outer space activities, and I personally hope that this is the model that it's going to be followed in the future, and that outer space remains one of the very rare peaceful and cooperative arenas of human activities. Now, as I mentioned, we had subsequent space treaties, and here I'm just going to briefly address what were the novelties that came with these treaties. I'm not going to go into detail because of time. So, as mentioned in the second treaty that was adopted, the Rescue Agreement, deals more with how to rescue and return astronauts and space objects. And here we have a definition that goes a bit further than just saying astronaut, as Article 5 does, and calls personnel of spacecraft is considered to be, all personnel of spacecraft is considered to be an astronaut. However, still this is not precise enough, and we are not sure, like, does personnel have to be someone who is able to do at least something on the spacecraft, or can it be simply a tourist occupying a seat in a spacecraft? So this still doesn't define completely, but at least it's a bit more precise than what it is in the Outer Space Treaty. The Liability Convention, as I mentioned, deals with the liability for the damages caused. And here we have two important principles, which I'm going to read to you. Article 2 says, a launching state, and as you can remember, we have 4 options of launching state, shall be absolutely liable to pay compensation for damage caused by its space object on the surface of the Earth or to aircraft in flight. So you see here the term absolutely liable means that it doesn't come to fault, negligence, anything. Like there is simply no excuse. If a damage occurs on the surface of Earth or to an aircraft that's in flight, the state is absolutely liable to pay for those damages. Article 3, on the other hand, says, in the event of damage being caused elsewhere than on the surface of the Earth to a space object of one launching state, or to persons or property on board such a space object by a space object of another launching state, the latter shall be liable only if the damage is due to its fault or the fault of persons for whom it is responsible. Now, this is a very different definition of liability, and as said, it addresses other cases which are not surface of Earth or aircraft in flight. Most, like, to translate it, it deals with damages happening in outer space. So if there is a collision of 2 space objects in outer space, and that's due to the fact that one state was not, for some reason, able to maneuver its satellite as it should have, and it collided with another satellite, that state is only going to be liable if fault can be proven. What falls under fault? There's many definitions of it, and there is no unified definition. So it's up to lawyers to argue if there was fault or there wasn't fault. It is somehow accepted that gross negligence would fall under fault. And as promised, to go just a tiny bit into more detail, the notorious Moon Agreement, which only has 18 states that have ratified it since the 79 when it was adopted. And there is no spacefaring nation that actually signed and ratified it. So it's the 18 states that have done it, and none of them are space powers. That is why the Moon Agreement is often, unfortunately, called the failed treaty, because states were not able to agree on many things, and at the end they adopted a vague text which can be interpreted in many different ways. And for that reasons, simply states were reluctant to sign it and to ratify it because they didn't want to risk how this is going to affect their future missions. And actually, the one provision which is causing so much reservation from states to sign it is Article 7, Article 11, subprovision 7, which talks about the international regime that should be established once the technology is there to extract resources from the moon. And under letter D, we see that this international regime should include an equitable sharing by all state parties in the benefits derived from those resources, whereby the interests and needs of the developing countries, as well as the efforts of those countries which have contributed either directly or indirectly to the exploration of the moon shall be given special consideration. Now, no one knows exactly what this means, and the technology is not there yet, but no state that perceived a possibility for their governmental agency or private actors to go on moon or to some other celestial body and to mine resources wanted to risk that this provision means that they have to then share these resources with other countries that did not participate in the mission. And for this reason, the Moon Agreement has so little ratification. And since the Moon Agreement, there hasn't been any new international space convention, but however, there have been other legal trends that have developed, which also point to legal issues that are currently existing. So no new conventions, but there were United Nations resolutions that were adopted, 7 of them. However, they don't have binding effect, and they only confirm the stalemate of binding norm creation that currently exists. We have also soft law development. Those are, for example, space debris guidelines, recommendations, codes of conduct, any such agreement between states that's not legally binding, but that expresses certain will to act in a certain way, is considered soft law, to put it simply. And soft law entails a high risk that states can simply ignore it. So they can all say, yes, we agree with the guidelines on space debris, but actually when they look to give license to their private companies and see that, for example, some satellite operator is not planning on following every guideline, they can still issue the license because they're not in breach of anything and they simply don't have an obligation to follow this. Third trend that is developing is on a national level, so not international, on a national level, the national space legislations. And we've seen a lot of national space legislations coming up recently. However, there is a risk in the national space legislations that countries unilaterally interpret the provisions how they see fit, which causes defragmentation of established legal principles. So if I say, for example, space tourists are not astronauts, and then there is another national space legislation which says, yes, space tourists are astronauts, like we lead to different interpretations of the provisions. And even though these provisions don't have clear answers, they should be regulated on an international level in order to avoid such different ways of interpreting, which can cause then more chaos in outer space, actually. And just to conclude, because I see we are a bit already over time and I know it's Saturday, I want to stress that outer space as a global common is in urgent need of safeguarding for 4 more reasons. This domain has become more interesting for many more states, and there is much more activity than it was when it was created. At the same time, we are having the lack of new norms that are regulating all these new activities. And on the third parallel track, we have, as I mentioned, new legal trends, but they entail serious risks for protecting the environment of outer space because they cannot regulate things unifying on an international level. And this is all because we have so many new actors and space missions, and simply all of this leads to a high risk of jeopardizing the sustainability of outer space. Now, I hope this introduction to the legal regime governing space activities was somewhat interesting for you, and that you would like to learn more and go with me into way more detail and talk about real cases and also practice with some some scenarios that would be built on real cases, how we could resolve that, and what you need to know, even if you're a technician or engineer, if you want to work on space objects and hope to launch them into outer space. So I invite you to sign up for a course that I will be giving on July the 1st. It's a 2-hour course, and we would go into the fundamentals, the main legal aspects, the legal trends, but we will deal really with a lot of practical cases and scenarios in order to understand all of this better. I want to take a thanks. Want to share my big thank to iSpace School once again for inviting me and for allowing me to hold a course with them. It has been a great pleasure, and I hope to see you on the 1st of July.
Thank you, Anya.